One of ICSID's webinar series, Investment Mediation Insights, providing practical insights into the field of mediation between states and investors. Our first series, which we aired in 2021, was very well received, and since then numerous changes, both in the practice of investor-state mediation and at the policy level, have occurred. We're excited to be able to share these with you today. And I'm glad to see so many familiar faces, as well as to be able to connect with new friends interested in learning more about investment mediation. So before we turn into our questions, let's recap a little about ICSID's activities in the investor-state mediation sphere. ICSID's mandate is to settle investment disputes. Initially, in 1965, when the ICSID Convention was first opened for signature, the procedures envisioned for the settlement of investment disputes were conciliation and arbitration. Over time, ICSID's member states expanded the range of procedures available, first in 1978, when fact-finding was introduced, and most recently in 2022, when ICSID's member states adopted a set of institutional mediation rules customized for investor-state mediation disputes. And my colleague will be adding in the link, a link in the chat to the mediation rules, as well as the page on our website setting forth information about filing mediation requests. Since the introduction of ICSID's mediation rules, ICSID has also published a background paper on investment mediation and an analysis of the mediation provisions contained in investment treaties. And we plan to publish updated versions of these analyses later this year. And I believe links to those papers were out in the chat as well. In addition, we've put together this new webinar series, which we're welcoming you to today. The goal of the series is to feature speakers who have practical experience with mediation, either at a policy level or in terms of their actual on-the-ground experience, having participated in a real investment mediation, either as a party, a representative, or a mediator. Sometimes mediation is considered an interesting idea for the future, but with this new installment, we would like to show that in fact the future is here. Mediation is already happening in practice. Today we're focusing on mediation, on the background of mediation and the process of it, including the policy framework for mediation at ICSID and within the context of the wider reform discussions at UNCITRAL Working Group 3. With me here is my ICSID colleague Frauke Nitschke, a senior counsel and team leader, as well as one of our close collaborators, Dr. Judith Knieper, legal officer at the Secretariat of the United Nations Commission on International Trade Law, or UNCITRAL, based in Vienna. Among other things, in her role, Judith has supported Working Group 2 on its work culminating in the Singapore Convention and Working Group 3 on investor-state disputes settlement reform, whose latest meeting was held just this past week. And more detailed information about biographies is available on our website. Before we start, just a quick note on format. This webinar series is intended as an informative and informal exchange. So if anyone in the audience has a question, please feel free to enter it into the chat and we'll turn to it as we can, either in the course of our conversation or towards the end. So now, finally, after I've said all of that, turning to you, Frauke and Judith. Judith, can we start with you? From your supporting role at the UNCITRAL Secretariat, can you tell us what brought mediation onto the radar of the states as one aspect of ISDS reform?
Yes, Anna, certainly, and thank you very much for the invitation and the possibility to speak. And thank you, Cesar, for sharing the slides. So I just want, before speaking about mediation, recall why Working Group 3 has been mandated by the Commission. So till the transparency standards, and that's why I'm starting with the rules on transparency and the Mauritius Convention and the transparency registry. Till then, we always developed all of our instruments in a generic way. So they were always fit for purpose for disputes between private commercial parties, for investor-state disputes, for state-to-state disputes, commercial disputes administered by institutions. So it was always meant to be all-encompassing. And with the transparency rules, we changed for the first time, we changed the approach, focusing on transparency in treaty based investor-state arbitration, because this issue was seen as, transparency was seen as something that we need to deal with differently in the investor-state context than in other contexts. And after we finalized these transparency standards, and maybe Cesar could change slides, we moved to, we got the mandate by the Commission to look more comprehensively at ISDS reform generally. So we did analyze, in the first step, we tried to identify concerns, and we did so these were concerns regarding the lack of consistency, of coherence, lack of predictability, the correctness of arbitral decisions. We looked at arbitrators and decision makers, and cost and duration of ISDS generally. And all of these issues were considered to be problematic, and all of these issues were said to warrant reform. So now we are in the third stage, which is the most difficult stage, because we are trying to develop solutions that address all of these concerns. And mediation was on the table from day one to respond and to address a number of these concerns I just mentioned. What you see here on the slides are all the different reform options that we are discussing. All of the reform options that have a little tick the box are those that have already been adopted by the Commission. The other reform options are still on the table, and we are still trying to work on them all at the same time to make sure that we come up with a comprehensive package at the very end of our reform process. And you see in the second green box that mediation has been something that has already been adopted. We have two instruments, we come to that later, but this is a bit the starting point of our discussions, and this is why we did engage in investment mediation, because states considered that that would address a number of the concerns they had regarding ISDS generally.
Thank you, Judith. That's such helpful context as we move forward into this discussion. And perhaps to add to that context, Frauke, can I ask you to share with our audience a little bit about the background of why ICSID decided to propose to its member states in 2018 the idea of introducing institutional mediation rules customized to ISDS disputes?
Yeah, thank you, Anna. Happy to do that. So there are basically on two levels developments that we observed that led us to propose to our member states the mediation rules. On the one hand, developments on the policy level. In 2018, the work on the Singapore Convention was in full swing, and we worked with UNCITRAL at the time. So the international community was grappling with mediation on cross-border disputes and enforceability of settlements already. In 2016, the Energy Charter Conference and 58 members at the time were also ICSID member states, developed an investment mediation guide already, putting mediation on the map. And then, of course, as we point out in the document on the treaty analysis, mediation provisions in investment treaties, that we saw a trend that our member states adopted mediation provisions alongside conciliation. And much like we did for arbitration, offering an opportunity to implement a process to give meaning to these provisions in practical details. And then, of course, empirical data that we see in ICSID arbitration, that about 30 to 40% of our arbitration settle. So the disputes settle without a tribunal ruling even after arbitration is commenced. So that suggests parties have a high interest in amicable resolution of their investment disputes. And so maybe mediation is as a form of facilitated negotiation can support that.
Thank you. And you mentioned treaties. As you know, sometimes treaties use different terminology, conciliation and mediation. And I wonder if we could take a moment to talk about that terminology. Judith, in the context of UNCITRAL, can you share with us the meaning of those two terms, conciliation and mediation, and how they differ?
They don't differ. So from our perspective, they are to be used interchangeably. When we started our first text in the area of conciliation/mediation, we used as the lead term the term conciliation. That was in 1980. And at that time, the term conciliation was the term that was most frequently used for a process where parties request a third party to help to reach an amicable settlement. When we drafted the Singapore Convention, states said that that terminology switched somehow on a worldwide scale, and now the lead term that was used, more frequently used, was the term mediation. So we decided to change the lead term. So we still say that, and you find a definition of that terminology in our model law, we still say that, so in 2002 in the model law, we said conciliation means a process, whether referred to by the expression conciliation, mediation, or an expression of similar import, whereby parties request a third person or persons to assist them in their attempt to reach an amicable settlement. So this definition has now been switched. We used the term mediation as the leading term, and our definition would now read, mediation means a process, whether referred to by conciliation or any other term. So for us, it's really the same proceedings. Mediation equals conciliation.
Wonderful, thank you. And Frauke, in the ICSID context, the words do have different meanings. Can you share with our audience the different sets of rules that are at ICSID and highlight the differences between them, please?
Happy to do that. In the UNCITRAL context, that also makes a lot of sense to not have a distinction between the two, to make all the text that you develop widest possible application. In ICSID, these terms denote different processes, and I highlight the main differences. We have a more detailed write-up on our website as well, but let's start with the scope of the process. For conciliation is open to member states and nationals of other member states under the convention, and similar under the additional facility where one or neither party is a member, but you still need a national and a state. And the mediation are much broader than that. There is no link to ICSID membership, and there's also no link to nationality. In fact, you don't need a dispute in the mediation context. We wanted to really offer facilities in consultations with our member states, of course, that we have facilities that offer mediation in the widest possible context if the parties so agree. Another aspect to mention here in that sense is the institution. Conciliation institution requires a pre-existing agreement to ICSID conciliation. In mediation, we open this up. There is a possibility to commence an ICSID mediation without a prior agreement to mediate, where a party submits a request to mediate under Mediation Rule 6 that contains an offer to mediate. The Secretariat will then take that offer and invite the other party to state whether it accepts or rejects the offer. If that offer is accepted within 60 days, we will continue to move towards registration. If we do not hear, or if the offer is rejected within that time period, we will not take any further action. In mediation also, there's unilateral withdrawal, so we call that ongoing consent. If a party agrees to mediate, it doesn't mean that it has to stay in the mediation until the end. It may withdraw unilaterally at any time. And confidentiality is perhaps also something to mention. Information in the mediation remains confidential, of course, unless the parties agree otherwise. The document or information is independently available, or disclosure is required by law. And ICSID will not publish the mediation, the existence of the mediation, unless the parties agree.
Thank you. So I think we can turn away from that very useful background. And Judith, you mentioned briefly the work products Working Group 3 developed in the context of investor-state mediation. Can you give us an overview of those, please?
Yes, and I would like Frida to ask to share again the screen, because to take a step back again, as already said, all of our instruments till the transparency rules are really developed in a very generic way. So all of the instruments are applicable to either dispute. And that's why I thought it might be useful to remind everyone of the mediation framework that we have available. So we have the Singapore Convention, we have the mediation law from 2002, which has been updated to also reflect the part on enforcement, and that's why you also have the new model law on international commercial mediation. I think this is the model law with the longest text we have. Then you do have contractual rules. You have the conciliation rules, you have the mediation rules. They are also fit for purpose in the ISDS context. You have recommendations for institutions that would like to tweak the ad hoc rules to the institutional context. You have notes which provide a general explanation what mediation is, also fit for purpose in the investment context. What Working Group 3 wanted to do is, in addition to prepare instruments that would nudge the use of mediation in the investor states dispute context. So we developed, in that context, we developed two instruments: the guidelines on mediation in international investment disputes, and these guidelines explain more specifically the issues that arise in investment mediation. So in addition to the notes, I would suggest to read these two texts together with the basic information in the notes and then specific targeted information in the guidelines. The second instrument we drafted were some model provisions for inclusion into treaty, because ICSID analyzed for us, if I may say, existing treaties, and the finding was that mediation was mentioned in some of the treaties, if at all, but that was it. There was no guidance. There was no, it was just said, go for mediation, go for negotiation, go for amicable settlement, but there was no real guidance. So what we tried to do, similar to an arbitration clause, we tried to guide the parties. So first we tell them mediation is available in these disputes. We tell them that they should consider mediation in these disputes. We inform them that they can agree on mediation at any point in time. And we tell them specifically what are the steps to do, so to take. Send an invitation, what this invitation should contain, to make sure that we ask the other party to make all reasonable efforts to answer to the reply of that request. We are a little less generous than ICSID. We only give 30 days for the other party to respond. We outline all the available rules that parties can choose from to have a mediation proceeding. For instance, the ICSID mediation rules or the UNCITRAL mediation rules. We highlight the relationship with other proceedings. We clarify that whatever is done in the mediation cannot be used in subsequent proceedings. And we also do highlight and emphasize the role of the Singapore Convention, asking parties to consider the requirements of the Singapore Convention so that this convention could be potentially used. So the idea of this mediation model provisions is really to provide guidance to the parties, to nudge parties to this possibility of using mediation at any point in time, using mediation in the international investment dispute context.
Thank you, Judith. And it is just one slide, but I know it represents an immense amount of work.
Since 1980.
In drafting. On the slides, we have some questions from the audience regarding whether they will be available at the end, and I will perhaps refrain from responding to that right now, and we will let you know in the chat by the end of the webinar whether that's possible. But I do have a substantive question I think we could turn to, because it relates to the background that we were discussing just previously. And it's a question from a participant in South Australia who asks, despite the umbrella term mediation, in practice, do third-party interveners like mediators in this context undertake a purely facilitative role, or do they also play an advisory and evaluative or quasi-determinative role? So providing settlement proposals and advice. And he notes that the latter is quite common in Australia. And I was wondering, perhaps, Frauke, if you wouldn't mind taking that question on very quickly.
Maybe we can merge that into the next portion when I speak a little bit about the process of how does a mediation work. And it says, if you could pull up a slide, then we can frame this, put this into context. Obviously, our participant knows a lot about mediation, and we want to get everybody else on board who may be listening in for the first time. So how does the ICSID mediation process work? We try to depict this visually here on the slide in basically 3 phases. Starting commencement phase, that is about structuring and organizing the process. I already talked about the registration of the request, which is very common in ICSID dispute settlement processes. And then the mediator appointment, where the Secretariat may facilitate based on our informal roster of mediators with experience in investment disputes. That will be followed by brief initial statements from the parties, setting out the issues in dispute and the parties' views on these issues, as well as their views on procedure of the mediation to be followed. Once the mediator has received these brief statements, there will be initial meetings, typically separate meetings between the mediator and the parties, to discuss initially what is the objective and object of the mediation, and then to prepare the mediation protocol, which is a framework document customizing the rules and creating really the process framework for the particular mediation. Once that is in place, the quote-unquote real mediation starts. And what happens actually in a mediation? There are separate processes. Different mediation providers have graphics about it. We try to summarize this as at the beginning, there's a process about gaining clarity, understanding the disputed issues, each party's views on these issues, and why they hold these views. This includes priorities that may be economic, financial, environmental, political, and to understand really what is the priority, because mediation is a process for reflected and really wise decision making in the interest of each party. Based on the clarity of these priorities, parties will start develop possible solutions with the mediator, and then that naturally lends itself to a negotiation phase, exchanging on proposal, receipt of proposal, gaining perhaps more clarity about priorities in a reaction and a response to a proposal, which aspects are of primary importance to a party that it considers particularly important. And then the closure of the phase in mediation in the context of investment. This process may take a while, especially if a settlement is reached, and this settlement might be subject of a review of a government accountability office or an attorney general's office, or in one case, there needed to be a parliamentary approval was needed to implement the settlement. And then we move towards the official termination with the termination notice from ICSID. Here we worked with our colleagues at UNCITRAL to ensure that the termination notice of a mediation reflects all the criteria set out in Article 4.1 of the Singapore Convention and meets these formal requirements. So with an agreement, the mediation may end, or without an agreement, and the parties may consider that mediation is perhaps not the most suitable process to resolve their dispute, and they move to other fora. So picking up on the question that you had in the chat, the qualification and the role of the mediator as assisting the parties in reaching an amicable resolution of their dispute. That is how we define it in the mediation rules. We did not prescribe whether this is to be facilitative only or whether this is evaluative in a sense that the mediator takes a stance on a particular substantive question or recommendation. We discussed this with our member states because, of course, our goal was to create a set of mediation rules that's globally acceptable. And we have a provision that the mediator may make recommendations if both parties agree. So we wanted to create a flexible framework that is adaptable to the desires of particular parties, but we did not want to prescribe from the beginning a particular mediation model.
Thank you so much, Frauke. And maybe Judith, you could help us if you could share whether there are criteria that you think states should be considering when determining the suitability of mediation as a process for investment dispute resolution.
As I'm working for the Secretariat, I'm of course neutral, but I can tell you that states defined criteria to consider to assess the suitability of mediation. So if I take the guidelines on mediation for international investment dispute, and you have there in paragraph 3, you have kind of checklist. What are elements that states should take into account when taking a decision? So I can read out some of them. The desirability of maintaining a relationship, the willingness of the parties to enter into a dialogue, the number of the parties involved, including with different interests. Maybe there are a number of stakeholders that you are unable to involve in a litigation, but you can easily involve in a mediation. The desirability to resolve the dispute time and in a time and cost-effective manner, the complexity of the issues, the usefulness to streamline the issues at stake. This is when mediation is not used to solve the dispute, but at least to see where really the disagreement lies. So mediation is also a tool that you could use to solve some of the issues and proceed with the other issues in an arbitration or litigation. The desirability of having control, any political, financial implications states might take note of. So this list of this checklist, which has been developed, maybe I should say, if I say UNCITRAL is an intergovernmental body, and to each working group session, to each Commission session, we do invite all 193 United Nations members. So the list is not a private list, but is really a list that has been worked on with contributions by the states and also with contributions from those, including ICSID, from those stakeholders who have experience in mediation. So I think if you read the list, you can see that mediation is really broadly applicable, and that is important at any point in time, also during an arbitration or after the arbitration, when you already have the award, but you have issues in complying with the award. So there again, in the enforcement, you might use mediation to find better solutions than those that are provided by the legal framework, more creative, tailored solutions.
Thank you. And Frauke, I can sort of put that question back to you also. When do you think, from ICSID's perspective, mediation can be used?
That is a great question. And if Cesar could put up another visualization of that, that we have, as Judith pointed out, we saw it in the policy framework already, but we have it in the empirical data that maybe we get to in a minute. On the slide, you see the investment dispute chronology and the availability of processes to resolve an investment disputes. And if you look at the life of an investment dispute and you accept that mediation as a form of facilitated negotiation is available, whenever negotiation is available, mediation could even be available at the outset of an investment, while operations are still ongoing and the dispute is developing a problem into a grievance, as our World Bank colleagues call it. And then the notice of intent to arbitrate may come, and a cooling off period. This is what you see under the first long line there. It's a part of the investment arbitration community, and in the early days, mediation was thought primarily of that period. But really, when we look at it as facilitated negotiation, it's available long before that and long after that, as Judith pointed out, alongside an arbitration or even after an award is rendered. And we designed the mediation processes at ICSID so that it could be combined with other ICSID dispute resolution procedures.
Thank you, Frauke, and you'll be happy to know that we have an active chat today. I'm going to turn back to a couple of procedural questions. I do see in the chat some questions about the qualifications for mediators, and whether ICSID maintains a panel of mediators, and we're going to turn to those questions in a little while. But before we do so, I maybe put to you some of these procedural questions since we've just been discussing procedure. So the first, we have two that are sort of two sides of the same coin, so I'll ask them together. Which is, to date, are most mediations in the ISDS field conducted more in a joint session, or is the practice more similar to the US style of bypassing the joint session and having the mediator shuttle in private sessions from the outset? And a related question is, can a mediator conduct a separate sitting of one party so that he or she can get a better understanding of the issues in the investment mediation? So maybe I could ask you to weigh in on that, Frauke, and then if Judith has any follow-up comments, she can make them.
Mm-hmm. Yeah, sure. We have that option codified in the ICSID rules that the mediator may meet and communicate with the parties jointly or separately. And at the first session, in the context of the mediation protocol that I pointed out, the parties will discuss in particular about the confidentiality framework for such private sessions between the parties. We will get to empirical data perhaps a little later, but from the research and the data survey that I have done, I have found over 40 investment mediations that have taken place and asked the mediators specifically that question. Is it joint session? Is it separate session? What is predominantly? And the answer was it's a mix. It depends on the process that the parties and the mediator design and what the mediator considers at what point in time most helpful. At the outset, though, at ICSID, what we have seen is that there is it is helpful to have, after the brief initial statements and before the first session, separate meetings with the parties for the mediator really to fully understand the disputed issues as set out in the initial statements, and for the parties to ask any questions about the process and to learn what is ahead.
Thank you. And perhaps you've answered this, but I'll just put it to you briefly. Can you share a little bit about what latitude a mediator has during the initial process to suggest a particular mode of mediation in the protocol? So, for example, to propose an ARB, mediation ARB protocol, as opposed to a pure mediation process. Can the mediator make those suggestions?
So generally, the mediator is leading the procedural framework within the mediation. In the ICSID mediation, as you can see in Mediation Rule 20, there is a list of items to be discussed at the first session and reflected in the mediation protocol. And one of these items concerns any agreements reached by the parties to suspend or not commence any parallel proceedings relating to the same dispute while the mediation is ongoing and pending. So this is part of these initial discussions to look not only within the mediation, but at the bigger picture of the processes that the parties have chosen related to the mediation. There might already be an ICSID arbitration ongoing, then the parties are aware of that. In the context of the procedural discussions within the mediation, maybe I point to Mediation Rule 22 on the termination. If it appears for the mediator that the solution cannot be found by way of mediation, the mediator has the ability to terminate the mediation as well. And so should the mediator consider that mediation is not suitable or there is no solution possible, the mediation may end, and in these discussions leading up to that, it might be an arbitration discussion as well. We don't have, as a procedural framework as such, an arbitration mediation hybrid. We discussed this with our member states at the time of the adoption of the 22 rules, and the idea was to best leave this in the hands of the parties, how they wish to combine processes should they see fit.
Thank you, Frauke. And perhaps you may just sorry, go ahead, Judith, please.
So I could not really contribute what is done in practice because we are just the standard setting body. So we are not administering, we are not getting involved in any case. But what I could say that, of course, our rules also allow for the different joint session or separate sessions. And the essence, I think, is that or the beauty is that mediation is really flexible. So it depends, this is for the parties and the mediators to agree on what should be the best way forward. And this is probably also the reason why, and Frauke mentioned it already, why we do not have a distinction between the two terms, conciliation and mediation, because we are not promoting one style of mediation or one style that might be called conciliation in some context. So from our perspective, all of our instruments are really all-encompassing.
Thank you. It feels like flexibility is a common factor. If we can turn away a little bit for a moment, at least from procedure to something relevant to the possibility of an agreed settlement after mediation. A treaty that's often discussed in this context is the Singapore Convention, which came into effect in 2020. Judith, you were involved in this firsthand. Can you share a little bit more about Singapore Convention, its scope, and how its applicability in the context of investor-state arbitration dispute settlement?
Yes, and I think that's why it's important to keep in mind that our texts are generic. So the Singapore Convention has been drafted in this with this generic lens that it should be applicable for all types of case. So it's applicable. The term commercial, and you find that explicitly spelled out in a footnote of the model law on commercial arbitration. The term commercial in our context is extremely broad and includes investment as well. There's maybe one caveat in the Singapore Convention because we have two reservations, and one reservation is that states may declare that the convention excludes somehow, let me see, it's Article 8. So there's the possibility for the state to exclude settlement agreements to which the state is a party or to which any governmental agency or person acting on behalf of a governmental agency is a party. So this would mean that you have such an exclusion, but from those 19 state parties, only very few opted for that reservation. So let's see how it develops further. For the moment, we still have, so we have 19 that are already party to the convention, which is very quick, considered that it has been open for signature only in 2019. And that we had the COVID pandemic, which slowed down treaty actions generally in a very significant manner. So we have 19 parties and we have 42, additionally we have 42 signatories, so those who are still considering but express their general readiness. And I saw there was a question from Australia, which also dealt with this distinction between conciliation and mediation. So Australia did sign up to the convention, didn't ratify it, so maybe if there's ratification, maybe that would trigger also the discussion on exactly these two terms and whether there are really differences.
Thank you. And if we can turn to the question of empirical data, I was wondering, Frauke, if you could share with us as a teaser, what are some of the things that you've seen? I know we're going to talk about them a little bit in future episodes of this series, but maybe briefly on that point.
Mm-hmm. Yes, as I had mentioned, we have identified over 40 investment mediation with state parties. We have shown that what Judith already alluded to, that there are the suitability of mediation is not limited to a particular sector or a geographical region of the world. A wide range of states have been involved, natural juridical persons, many industry sectors. The basis of consent to investment mediation is found in ad hoc agreement, so meaning the parties agreed to mediate after a dispute had already arisen, or on the basis of a contractual provision. The empirical data confirms what we saw on a graphic earlier, that mediation is available pre-arbitration, alongside arbitration, or even after an award has been rendered, post-arbitration. Duration here is interesting, 1 month to 2 years, with the majority under 2 months or around 8 months, around 8 months, with a particular time period dedicated to the finalization of settlement agreements, taking into account approval processes on both the investor side and on the state side. Cost of the investment mediation, majority for process cost, around excuse me, under $25,000 and a max with $100,000 per party. So.
Thank you. And then there's a few more topics we'd hope to cover. I'm not sure if we're going to get to all of them, but we did have a couple of questions in the chat about who the mediators are, whether they should have certain qualifications, how cultural aspects should be taken into account, and a related question about whether ICSID maintains a panel of mediators and how that is filled if it exists. So perhaps I could ask you, Judith, to share your thoughts on what the profile of a mediator might be. And then Frauke, perhaps you could share your thoughts in the context of ICSID.
I think my answer would be a typical lawyer's answer. It depends. But again, in the guidelines, we put together some aspects for consideration. So if you read paragraph 14 to 20, you have some aspects to consider. So the experience as a mediator, the ability to conduct a mediation in an effective manner, the training, the experience working with governments, experience in different forms of dispute resolution, experience in investment, of the investment context. So all, and cultural aspects, all of these issues really are up for the party to define upfront what would be important for them. What I've heard of, so as I already said, we are not monitoring any of those issues on a systematic basis, but what we have heard is that often the parties opt for co-mediation if they really have to bridge different cultures. So each party would have a mediator of her own culture, so that these two mediators could try to become the translators of the issues at stake. So that is certainly one possibility. But it's really, really up to the parties. That again, flexibility is probably the key word for them to define what would fit best to their case at hand.
From the ICSID side, I can add that we also have identification of factors parties can consider in our background paper. I believe we have the link in the chat at the beginning. One thing that is clear, as Judith identified, mediation is a facilitation of negotiation. So it's a considerably different skill set from that of an arbitrator, for example, who decides disputes on the basis of the applicable law. And experience and training is certainly something to take into account. And we talked about the co-mediation, just for our audience. Co-mediation is two mediators, both appointed by party agreement typically. And then parties may choose that if one mediator does not possess all the qualifications, perhaps on substance of an industry sector, of a language, of a cultural background, then parties may opt to having two to assist the negotiations, which in particular complex disputes we have seen can be a very effective method.
Thank you. So that really brings us to the end of the time we have available. I would like to thank all of our participants for the many thoughtful questions that they included in the chat. I'm sorry we couldn't get to all of them, but rest assured we will be looking carefully at them and see how we can work to address those open questions that we didn't get to discuss in our future episodes. Which brings me to the end. Thank you both, Judith and Frauke, for sharing your insights and knowledge about the policy landscape and activities in investment mediation that we've seen in the recent years. There's certainly a lot of developments there, and I thank you for sharing them with us. That concludes our first episode of ICSID's webinar series, Investment Mediation Insights. We hope that you found it informative, and we certainly enjoyed having you all on board. We look forward to welcoming you again to our next episode. This will take place on October 22, 2025, starting at the same time of day. And in this one, we will be discussing mediating from parties' perspectives, discussing with representatives for states and investors various aspects of investment mediation. What are the factors states have considered when deciding to mediate, when lawyers will recommend mediation to a client, and how the role of a party representative may differ between mediation and arbitration. So we hope to see you then on October 2022. And until then, thank you very much and stay safe.